Right here. The role of summary judgment is really just for things that are frivolous on its nature. It would be equivalent to JOA that we have in criminal court, where the charges haven't been proven or the case has not been proven. And I don't believe that it's a violation of our Constitution. We've got the rules of procedure, we've got the law that's written by the legislators. I'm not running to change the law. I'm not trying to legislate from the bench. My role as a circuit court judge would be to follow the law that's established.
Same question.
Same question? Okay.
Yeah.
Sorry about that. Okay.
Summary judgment does have the same, in civil court, has the same role as a judgment of acquittal in criminal court. And I think most everyone here would agree that the court system is not supposed to be used to bully people, harass people, or be a money-making venture. And some folks try to do that with the court system. Summary judgment allows judges to pull the plug on cases that can be proven, that don't have what we call a prima facie case to move forward to, say, a jury to decide. There's just not enough there, threshold, to move on to the next level where a jury or a non-jury trial will take place. So summary judgment, we wouldn't have it if it violated the Constitution. I think it's very necessary. A lot of people complain about frivolous lawsuits that go on in this community. That avenue allows courts to weed out some of the cases that should be going through.
Same question still?
Yeah.
Okay. Oh, okay, thank you. I didn't know if it was by group. I'm Ken Lark, Group 2. The summary judgment issue in the civil side is whether there's a genuine issue of material fact. And if there is no genuine issue of material fact about that particular lawsuit, an element that may be missing, then it's appropriate for the judge to enter summary judgment. Now, the problem that we sometimes see is when is it timely to allow that kind of motion to be heard to dispose of the case that way, rather than going to have a trial or some trier of fact to decide the matter. And I think that's probably where the rub comes in. And I don't personally see it as a constitutional issue. Summary judgment's been around for much longer than any of us have ever been sitting here, so, or been alive. So I don't really particularly see a constitutional issue on that fact. And that's it. We can learn. Thank you.
Well, I can tell you this. I've filed motions for summary judgment. I must be in the realm of 100 times in my career. I represent a bank, and we do foreclosures. And I can tell you that we do motions for summary judgment all the time. There's no genuine issue of material fact, and our bank wants to foreclose, and they don't have a legal defense, then we can do that, and the judge can get us an order right away. Now, when you have a deal, an issue like foreclosure, and I believe that Ms. Sharp talked about this, when someone comes in and says, I want to have my moment in court, then most judges will allow them to have their moment in court. They will let them talk, let them get it off their chest, and that's a good judge. A good judge would let them do that, or her do that. Get it off their chest, and then grant the motion. But I don't believe it's a constitutional issue. I don't think that it violates the Constitution in any way. And I do think it's a necessary element because it does move our cases forward. Otherwise, we could be waiting 6 months to get a trial. We can wait 2 months to get a 15-minute hearing. Alicia Paul, thank you.
Good evening again, Al Rosenthal. My colleagues have said it all. They're very skilled lawyers. They're right. It's not a constitutional issue. It's a procedural issue. And it's a procedural issue that allows the expedition of a hearing that is frivolous in nature. Why would you want people to bring lawsuits, waste your time, your effort, your court resources, which are limited already, with a lawsuit that has absolutely no basis in law or fact? If there's not a material issue of fact, there's no reason to go forward. Thank you. There's no reason to waste our valuable court resources on issues that can be easily decided. So it's not a constitutional issue. What it is a mechanism to allow the court system to get justice very rapidly and at a very low economic cost, because trials are expensive, and if you're on the other side of the lawsuit where you're being harassed by a frivolous lawsuit, you would very much appreciate winning a motion for summary judgment. Thank you again, Al Rosenthal.
Thank you. Excuse me, the summary judgment rule is contained in the Florida Rules of Civil Procedure, also in the federal rules. And I've handled many complex cases during my career. And usually what happens, and I'll answer your question in a moment, but usually what happens at a summary judgment phase of a case is that the party that's moving for summary judgment and the party that's defending it will file various types of documentation into the record, depositions, affidavits, and other material that the court will look at. And if the court feels that there are sufficient facts in dispute and the party that brought the claim has met the elements, then the summary judgment motion would be denied and the case would move forward. As it relates to whether it's a constitutional issue or not, the procedural rules relate to, and those are approved by the Supreme Court of Florida, the civil rules of procedure, which include summary judgment. But for me to state that I have a position as to whether or not it's constitutional or not as it relates to some issue that could come before me, I don't think would be appropriate for me to answer. I don't know what argument potentially could be made in the future by anyone who would be for me as it relates to that particular type of issue. So I don't think I would comment on that at this point. Thank you.
I agree with all the candidates that I don't think we can comment on it being a constitutional issue, but summary judgment is important, and I've gotten summary judgments, but there's a little bit of confusion sometimes with it. It's not that you're taking the right away to have a jury trial or to have a fact finder decide, because fact finders decide facts and dispute it. They don't interpret the law. So, for example, summary judgments are used sometimes when everybody agrees on the facts. We don't need to have witnesses. We don't need to have that day in court for those disputed facts because everyone agrees on the facts. And it's up to the judge to determine the law and how to apply, as a matter of law, those facts to the law to come up with a decision. So in that case, you're not taking a right away to have something heard by a fact finder because there are no facts to have decided. And that's the purpose of summary judgment, so that we can increase the efficiency of the courtroom and try to unclog some of the cases that get clogged up in the system. So, Kim Sharp.